has contributed to the international legal discourse as a speaker at the World Trade Organization Public Forum, where she has engaged with global conversations around trade, development, and equity. She is deeply passionate about blending domestic constitutional practice with international policy insights and furthering conversations on how India can strengthen women's rights within both national and global frameworks. I now request Ms. Anindita Mitra ma'am to lead the panel discussion on bridging the gap, strengthening women's rights through the 3 pillars of the Indian Constitution. Ma'am, could we please have you on stage now?
Good evening once again, everyone. Thank you for being here today. It gives me immense pleasure to welcome all of you today to today's panel discussion on a topic that is not deeply significant, but also very, very urgent. Bridging the gap, strengthening women's rights on the 3 pillars of the Indian Constitution. While the Constitution lays a strong and visionary framework for equality, justice, and dignity, the real question before us today is, how effectively have these promises translated into lived realities for women all across the country? In the recent years, we witnessed both progress and pushback, from legislative reforms aimed at empowerment to judicial pronouncements expanding the interpretation of fundamental rights. However, the gap still remains between law and enforcement, between rights on paper and the rights in practice. This discussion is an opportunity to critically examine how the legislative intent, judicial interpretation, and executive implementation can work in harmony to ensure that constitutional guarantees are not just ideals, but actionable realities for women, regardless of their caste, class, or location. I'm now going to introduce our panelists, who are extremely distinguished with years of practical experience to lead the way on this panel discussion. Our first panelist is Honorable Ms. Justice Rekha Palli, a distinguished former judge of the Delhi High Court, with a career in law spanning several decades. Prior to her elevation to the bench in 2017, she practiced extensively before the Supreme Court and various high courts. A significant chapter in her illustrious career involved spearheading the legal battle for gender equality in the armed forces. Her unwavering advocacy and passion for gender justice culminated in the landmark judgment of Babita Punya and others versus the Secretary Ministry Defence and others, which resulted in grant of permanent commission to women in the armed forces. Thank you for joining us today, ma'am. Our second panelist is Dr. Pinky Anand, a senior advocate in the Supreme Court and former Additional Solicitor General of India. She is a recognized arbitrator and has been instrumental in leading the ADR Committee of Law Asia and contributing as a founding member for the BRICS Legal Forum and the ICA. She is also a door tenant at the renowned No. 5 Barristers Chamber, London. A graduate from Harvard Law, she has a distinguished legal career at the bar for over 40 years. It's a privilege for us to have you today, ma'am. Thank you. Now our third panelist, Senior Advocate Meenakshi Arora, an absolute trailblazer in the Indian legal landscape and a leading voice for constitutionalism, gender justice, and commercial litigation. Meenakshi ma'am has appeared in several landmark cases, including the seminal Vishaka versus State of Rajasthan, which laid down guidelines to address sexual harassment at the workplace. She also served as the Supreme Court's Gender Sensitization and Internal Complaints Committee, playing a key role in drafting its 2013 regulations. Meenakshi ma'am's steadfast commitment to gender equality and civil liberties truly distinguishes her contributions to the legal community. We welcome you, ma'am. Our fourth and final panelist is Anitha Shenoy ma'am, a distinguished senior advocate at the Supreme Court of India, recognized for her expertise in constitutional law, public interest litigation, environmental law, and civil and criminal litigation. Designated as a senior advocate in 2019, she is a trailblazer in environmental law, notably arguing cases like the Mopa Airport case, a 1995 graduate of NLS, Anitha ma'am served as the standing counsel for the state of Karnataka for over a decade and has represented organizations like the National Human Rights Commission and National Legal Services Authority. We welcome you, ma'am. Can we now invite the panelists to come up on stage? Hi. That's quite the panel, isn't it? Thank you so much once again for being here. I'll just quickly explain the format for this panel discussion. We've divided into two segments. The first one is where we invite all our panelists for their opening remarks on the subject matter of the panel discussion. And after their opening remarks, we'll get into a Q&A format. May I invite Justice Palli for her opening remarks?
I think I've just seen Justice Vishwanathan. A very good evening, Mrs. Vishwanathan, all other senior advocates and members of the bar. A very good evening to all of you. Justice Dave, sorry, my mistake. No, how could I miss such a tall figure? And my mistake. My mistake, sir. I really apologize for that. And I hope I look around, I hope I don't miss anything. Nidhi is like, yeah. Justice Nidhi Gupta from Chandigarh, who's taken the trouble to come all the way from there to attend this. A very good evening to all. First, I must say that I'm actually really joyed to be a part of this landmark moment when Ms. Pavani's book is being launched, not as a judge, but as a fellow lawyer, with fellow lawyers. So that gives me the biggest satisfaction. This is the place where I belonged, and I'm back there again. Ms. Pavani has been a real fighter for women's rights, and her hard work, if you see, shines through every page of the book. People who have been able to read the book can see how she has accumulated, made it into chapters. She has a reader's remedy section for everything. So the book is very different. It's not only a collection of legal provision, but it also guides the general readers as to what they can do if they are in trouble. Like if there is an example that if there is a case of teasing, you can file a zero FIR. So that what makes the book more commendable, that it gives you in a very simple manner what to do. See, having been part of the legal system for years together, first as an advocate, then as a judge, and then now again as a fledgling lawyer, I would call myself. I'm trying to find my feet there again, but I have seen that sometimes women feel very helpless because they don't know the basic legal provision. They don't know they have so many rights which they can. So that's where the book will come. It's a very critical book for that, right? That it gives you the provisions for the journey of a woman through the entire lifespan. That is how the book is special, and I compliment Ms. Pavani for this hard work. And I hope the book is a real success. Now coming to the topic today, that how you will bridging the gap, strengthening the rights of women through the three pillars of the Constitution. Saying that the rights of women need to be strengthened today in itself shows that we are conscious of the fact that even after more than 7 decades of the Constitution having come in, we are still struggling, we are still trying to talk on this topic that women's rights need to strengthen. The journey has been slow, but we have succeeded to a large extent, in that sense that when I joined, I will give an example, when I joined the profession way back in 87, I could just count the women who were there in the High Court or Court. Now you see, when you go to the Supreme Court, you see at least 20 to 30% lawyers, maybe not all of them are arguing that they will also come, that you will see those 30% leading the way. That now you see a number of law. Same is the case in Delhi High Court was able to designate only 15 senior advocates from 1969 till 2020. And in recent past, we have designated 13 senior advocates, 13 ladies as senior advocates. So the shift is there. We are bridging the gap. I would say that this is coming because the Constitution, by its provisions, had set the spark. The spark was there. It is these three pillars which have worked together gradually to bring the change. And the biggest change which I see is that earlier women were seen as victims who needed protection. 10 years ago, 20 years ago, you would talk like, "Bichari ko ye chahiye hai, bichari ko tang nahi karo." Now things are changing. Now we look at women who have independent voices, independent thoughts, and we want to hear them. And the very fact that this panel also has only ladies shows that people are Justice Dave sitting here in Vishwanathan. That's the change. The shift is coming. But how do we do it? How do we go ahead? If we talk of, she's already Anindita already told us how the legislature has stepped in. The legislature, it's ultimately the people's sentiments are enacted into laws, but ultimately who has to implement them? It is the executive which has to do it. The policies have to be framed, the laws have to be interpreted by the judiciary, and that's where the key lies. The laws will keep coming. We have to ensure that the executive and the judiciary remain strong and conscious of the fact that women must get their dignity and must be able to work with the same freedom which men get. Having said so, I would say that though we have come a long way, there is a lot to be achieved yet. There is a pay gap, I think, in the profession also. I don't know whether my colleagues would agree or not, but yes, even in see that not only it is having said, remain that side. As a judge, you don't find that gap, but as a lawyer, you do. As a lawyer, you do find. See, a lot of them are nodding their heads. That pay gap is also there. For the same work which a lady does, you get 40 rupees. For a man, it's 100 rupees. That's the global index, gender gap index for our country, and that is there for every profession, most professions. So that we have to break that. We have to but we have to be patient. We have to slowly prove ourselves, go forward, and not be so this thing, because ultimately we started with almost something where we were being treated only as property. And there I'll talk of the two decisions of the apex court where the judiciary has come, and in the recent case of Joseph Shine, the court has said the wife is not the property of the husband. She has her own dignity. And that shows that it is not only the constitutional mandate the court is emphasizing, it is the society, it's a message to the society. It's a message to the society. As a judge, I was dealing with matrimonial matters. I mean, this is something I'm sharing. I would find husbands coming and saying, "My wife talks like this." I said, "So what?" I mean, it was very difficult and I was luckily, or whatever it is, I was sitting with a male colleague who was junior. So I was doing most of the talking. And then they would realize that, yes, I would tell him that, see, you have to, or you can't be, that's the message going to the society. That was a message that women can command, if they have the capability, they should be given. So the judiciary plays an important role in that. Executive, of course, is coming up with a lot of schemes. Now we have that Beti Bachao, Beti Padhao, Ladli Behna, and all those schemes. So we have to, the executive has to prioritize funds so that these policies which are only put on paper, like earlier we would hear of policies, we will give this to women, they are actually put in place. With that, I think I will only say that we are bridging the gap, but with seminars like this, it's not, the day is not very far when we may not have to discuss all this, and maybe men are going to come and say, with all the best and to it.
Thank you so much, ma'am. May I now invite Pinky ma'am for her opening remarks.
Good evening, everyone. As a typical lawyer, it's nicer to stand up on the podium. Justice Rekha Palli has done her bit very well from there, but I thought I would use this opportunity to be a typical lawyer and stand up. That's the way we do. It's like we just watch the courts and we say, hello, Justice Darling. We are grateful for your presence. We've had very exciting times with him. And I must say that when we talk about gender justice or gender equity or gender fairness, at least the two judges who are sitting here cannot be in any manner accused of not being in the field where they have in every manner encouraged the process of gender justice. Ladies and gentlemen, what a wonderful occasion. Mahalakshmi has always been an active member of the bar. She's always enthusiastic. Nobody would say that she's not. Vivacious. And to come out of the book from the womb to the tomb. Incidentally, when talking about the tomb, there's something that occurs to me. I remember when Triple Talaq was being argued and we were preparing the Supreme Court before the Constitution bench. One of the arguments that Mr. Simple, appearing for the petitioners, no, he was appearing, yes, for the petitioners, he made was that, now people are interfering with women's rights as far as marriage is concerned, and ultimately it will be interfering in people's death rights. And everybody was shocked. Actually, when you talk about the tomb, it brings the fear of God in you. And you keep fearing that if this is the position, what will happen? But having said this, we've gone a long way. I think what is most interesting to me, and what is most interesting, and I repeat this, is the fact that the narrative has changed. The narrative from using gender discourse as a side subject or as something to be hidden under the carpet to a subject which is in the forefront. And it is the forefront of all narratives, globally, nationally. We have today, ladies and gentlemen, ultimately women and men on the same level of voters' representation, which is an amazing development in the political field. The fact that women are there, voting in equal participation, exercising their political rights, because ultimately I do believe that as a citizen, that is one of the most important components of your rights. And you also have a time now with Beti Bachao, Beti Padhao Andolan, which just now Justice Palli had just mentioned. I remember one of the most striking things I have in my mind when we talk about voters' representation. A girl who's taking a bicycle and saying, Papa, aa jao, aapko voting ke liye le jao. I mean, that is what ultimately the difference is. Where the father used to take the daughter and say, yahan vote kar dena. Where the daughter is asking the father, come along, I'll take you for the voting and you can exercise this right of voting. So as I said, a long discourse. You talk about the 1980s, you talk about the 1990s, you talk about now 2025. A lot of water has flown and we have flown with it. We have flown in every manner with it. Why? Because you have opportunity. You need to have that opportunity, but to exercise that opportunity, you need to be given the forum, the entire position where you can access that. So I believe access is very important. And in that field, I feel between the judiciary, between the legislature, between the executive, I think every possible encouragement has been made. Laws have been developed right from the development of 498A, 406 interpretation in Pratibha versus Union of India, ultimately to come to a position where today we stand strong with every ability to participate in that exercise. We have representation in all manners, which is far progressed. Lok Sabha, 15% odd. Little lesser representation in the judiciary. We have only 2 women in the Supreme Court, about 15% in the high courts, and a fairly low percentage in the subordinate courts also. But that is ultimately a matter of time. What we have just discussed recently in Shobha Gupta's case in the Supreme Court, and Fawzia was also a member of that, we actually fought for reservation for women lawyers in the Bar Association, because Bar Association never had a woman president, the Bar Council never had a woman president. And ultimately somebody turned around and said, are you going to be standing for the High Court bar elections? I said, no, I have no intention of standing in the reserve category, or otherwise for that matter. But having said that, the fact that there is no time to wait, you need to come up there. And you need to come not only in the middle level, at the subordinate levels, but at the top level. So at the policy levels, at a decision-making level, I think that is the target that we are looking at today. And I, of course, it's completely concur with Justice Palli to say that you need to implement them on the ground. What is the position, mindsets, stereotyping, ultimately characterization? For example, very often women will be said to be very good professors. You can be very good professors, but you can't be possibly a very good lawyer. This classification is something that I think has been frowned upon very deeply by even Justice Chandrachud recently in his book, where he brought out these phrases which are negative or otherwise inimical to women. So with this in mind, I think the judgments, the way they have dealt, we have aberrations. Allahabad High Court recently had a judgment which in circumstances of a 14-year-old girl ultimately had positions where it held it not to be an attempt to rape, even though circumstances are such, and I don't want to go into detail, all of you read about it. Supreme Court of course frowned upon it and said you can't do this and you should do this. Is a suo motu cognizance by Supreme Court. Just yesterday or day before, you had the position of no means no, not being taken seriously again by the High Court. Again, Supreme Court in another judgment, not in fact against that order, but again in another judgment held that this should be more sensitive because the said conduct. What did a woman do? How did she behave? Maybe she asked for it. And time and again, these have been struck down. I think ultimately the message is going down constantly. The ability to be able to translate it, I still remember there were some instances in UP during election time and otherwise, when statements are made like by senior people. I think boys will be boys and boys will behave like this, or men will be men and they'll behave like this. Honor killing, ultimately it is held very much so. It's a matter of honor. Actually, it is a matter of dishonor. I appeared in the matter in the honor killing case, and Supreme Court came down fairly heavily and gave a diktat against the Khap Panchayats, who ultimately engage in these practices where people have no right to choice. But now we do stand with rights being endorsed on paper as well as in practice. We lack the ability sometimes to be able to translate it down the line. For that we need access, we need information, we need also assertion of rights. I think that's the last keyword that I would have on this. Very often women will not assert their rights also because they feel it is alright either to be in that position. For example, in a typical case of inheritance, women will not enforce their rights. They will give it up in favor of their male brothers or whatever else is there in the family. We need to assert our rights, and if we do assert them, definitely people like Justice B.V, Justice Vishwanathan will support us all the way. Definitely people like all of us on the panel will stand along with you in all your fights, and definitely most of you here in any case are there. You're already there right at the top. It is only a matter for us to get everybody on board, but I do believe it should not be an exclusionary principle. I do believe it should not be over-excessive. I do believe at times there is some kind of use and misuse of certain provisions, and I do believe one more thing. I do believe we should stop having multiple remedies. We must stop having that. This over-exercise of providing remedies sometimes can be detrimental to the cause of women also. In fact, recently I was made chairman of the POSH committee by the Bar Council of Delhi, and we were just wondering because there are 5 different forums which can engage in the same exercise. You can't have that multiple situation happening. So we must be able to curb, we must be able to focus, we must be able to target, and we must be able to orient. With that, ladies and gentlemen, we look forward to a very exciting evening. Thank you very much.
Thank you.
I've got my book here just to show you that Trials of Truth, which incidentally, just as a last statement here, when I was writing it, my aim was not to write as far as only women's rights were concerned. But I did find at the end of the day that it became a story of women's rights and women's victimization because women very often are the victims and not the other.
Thank you so much, sir. May I now invite Meenakshi ma'am for her opening remarks.
Good evening, Justice B.V, Justice Vishwanathan, Mrs. Vishwanathan, dear friend Nidhi, and of course, Mahalakshmi, many congratulations to you. I'm not as good as my friends to really speak completely extempore, but for today, I decided to speak on something which came as very close to my heart. All of you seem to always associate me with Vishaka, and I want to say, Vishaka is a far cry from what had happened about 100 years ago in a small town of Madurai. And I want to narrate that what we are doing today, there were women before us who had gone much further. We lost it somewhere perhaps in between, but now it's time to take the movement forward. So this is a very small story, and please remind me when my 5 minutes are up. This is Madurai Mills was set up sometime in 1892 by the British. It had about 1,700 odd people working for it, and a fair number of women. And by the way, in sometime in 1930s and 20s, there were a large number of women who worked in the mills in Mumbai, that was Bombay then. And as the story goes, somewhere with the advent of mechanization, but more with legislation. For example, the Maternity Benefit Act, which came in at that time, it is said that it resulted in their exit from the mills in Mumbai. Now, in the early 20th century, there were a good number of children, women who worked in Madurai mills, and it was a large force. About 30% of the entire workforce was women there. What I speak about today is the first major strike. During that period, where women sought to unionize themselves, and this is a very infant stage of unionization in India, led by women, and demanded the removal of what is called a maestri, a recruiter come a manager, whom they accused of sexual misconduct. The time period, 14th April to 10th of June 1920, in the town of Madurai, in a mill. Women went on a strike. They told their manager, who was one Britisher, Mr. Gillespie, and said, you remove this gentleman from there, unless and until that's not done, we go on a strike. All the women walked out of the mill on 14th April 1920. Men came out as their supporter, initially of course, and therefore added with their right. Now women, while they were striking from 14th April onwards, they came up with another demand. They said, we want to now join the unions. It became a list of one of their demands. These women were in... We welcome Justice Hima Kohli, Justice Bhushan. It's good to have you here this evening. Now, as I was saying, these women, way back in 1920, they were neither passive nor they were reticent. They came across fearless, assertive women with a voice of their own, demanding a fair deal. They were also not protected women, by the way, at that time, and they were actually quite at the receiving end. They were the part of the crowd that rebelled against injustice, and sometimes they also rebelled violently against the manager. But let's not forget one thing, that the supply price of a woman labor was always, and is even today, as has been said just before me, is lower than that of the men. Now, this is actually rooted in what was promoted perception, and I emphasize my words, promoted perception of gender roles, which were promoted by and large the economy, because the family intended that the family, gender in ideology must stay, where man is the provider largely, women are submissive and passive, and that is where the ideology led. Also, in fact, to their work areas, where they got lesser salaries, lesser pays than the men did. There's time for change, but we are still talking about it, which is really not very happy situation. Although the laws today say equal pay for equal work, but if you translate it into an unorganized sector, it really is not so. Anyway, well, I'm not digressing from what I wanted to say. Also, let's not forget that all these women, the 30% of the women of the Madurai mills, were all those who worked on the lower rungs in the work hierarchy and consequently were much lower paid. 700 odd women who started with this particular particular demand for payment of their outstanding dues, and they said, pay us all our money up till 13th of April, a day before they went on a strike. But the manager would not relent. He wanted people to come back. So they were without the money. What happened? Unfortunately, the men started to go back to the work and left this particular strike. Slowly, women, some of them also broke away from the strike, leaving very small, dwindling crowd of women who were protesting against the removal of the man who was alleged of sexual misconduct or asking for their rights of unionization. The strike may have failed in 1920, it did. But amidst all these happenings, there are two things that happened. One was a nationalist who was a rich man in Madurai, who saw what was happening to the women and people. He said, why should I not set up a mill which will not be run by the British? So, advent of the thought of the Swadeshi movement. But finally, in June of 2020, men, women have joined back work and the strike was over. Be that as it may, I would say that strike was not a failure. It was the first instance of its kind in India. Not for any economic demand, but for a demand of dignity. And I think that's a very significant demand to make, a demand for dignity. And they asserted their right to organize collectively, put their demand, and way back then in 1920. Now I come back to what is it with us today. We had Vishaka Declaration in 1997. The legislation came in 2013. It took us 16 years to have a legislation. Coming fast forward, I would say, we have a lot of laws, but the important part of our laws is an implementation. We are coming down very sharply when we look at the international rating. India has gone down from 123 or 24 to 129 in terms of its legislation and its implementations, which is not a very good thing for us. But I do believe there's one area where women are required to be more in their numbers and more in representation, and that is the political scenario. That is the Legislative Assembly, the Rajya Sabha, the Lok Sabha, and that 33% reservation that was a talk sometime back is very important. I will add it in I'll just end this in 2 minutes by saying, countries like Africa were embroiled in huge amount of genocide on the basis of tribes, conflict, etc., particularly Rwanda, Sudan, and the other countries. After the last genocide, women decided to take matters into their own hands. And this came to me from women who are actually now in very high places, leading in the political sphere in these countries. They felt that where these fights are happening, they lose their men, their sons, their brothers, everyone. They felt that if they were in the position of political power, perhaps they would insist that these kind of fights, disputes should not take place. Women, after all, are homemaker, and they treat the world as large as their home and keep the families together. The representation of women in countries in South Africa, which were affected by conflicts, went up to quite 60-odd%. 60-odd%. We do not have even 17, 18% as of date. And they made a difference to their countries. I would say the one area that we still lag behind is our representation. Women now need to move out of the comforts of their homes, their jobs, their areas, and take over the political sphere. We need to save our countries, our democracies, our rights. And if we had this 16 years to have one legislation for women to come through, which was the Sexual Harassment Act, or for the Act of Amendment of our rape laws, which had been pending discussion for over maybe 2 decades, almost 20 years, if it took them so long to do these legislations which concerned our rights, it's only about the time we realize that our next movement should be the Parliament houses. Thank you so much.
Thank you, ma'am. May I now invite
excited to be here today. My dear friend Pavani has authored this book. Very well, I'm sure it's beautifully written and much needed. And this is also a different, apart from her, her commitment and the fact that she's filed so many cases pertaining to women, this is an extension of her work. Now she's put everything in writing, and I hope it will be a very useful read. We all welcome Justice Nagarathna. Carrying forward, I'm neither can I speak extempore, nor am I taking the storytelling route. Mine is a fairly boring textual speech, but taking the discussion forward, what we were able to see is that, this is, despite the existence of a very robust legal system, there are over 40 central legislations directly or indirectly impacting various aspects of women's lives. I mean, starting from, say, the PCPNDT Act, which talks about gender selection, which talks about prenatal diagnostic techniques where you do sex determination tests, to the other end of the spectrum where you have Dowry Prohibition Act, you have Commission of Sati Prevention Act, then you have employment related legislations, which is the Equal Remuneration Act. You also have laws and amendments to the Hindu Succession Act, and so on and so forth. So the point I'm trying to make is that as far as the legal system is concerned, or the laws are concerned, I think there are quite a few number of laws relating to every aspect of women's lives. Now, that's one aspect. The second aspect, of course, is the judiciary. Now, time and again, constitutional courts have stepped in, either affirming equality and have made it it's not just ornamental. These decisions have not just been ornamental, they have been operational. And judiciary has stepped in, in terms of breathing life into these laws. Like I personally remember the PCPNDT Act was there, I think in 2006, until the Supreme Court stepped in. People didn't even have a copy of the act, the people who were supposed to enforce this legislation. So you do have, on the one hand, robust legal system in terms of the laws. Then you have a lot of judgments which span across all subjects. Like you have laws on, you have judgments like the Gita Hariharan judgment, which interpreted it granted mothers equal right as natural guardians in certain situations. You have the Vinita Sharma judgment, which affirmed that daughters have equal co-partnership rights by birth under the Hindu Succession Act. Then you have laws, you have judgments in the employment of the workforce. In workforce, like for instance, the Babita Punia judgment, which marked a milestone by extending permanent commissions to women in the armed forces. And it's really reinforcing that constitution doesn't stop at the barracks. Or you have the Air India versus Nargis Mirza case, which my senior argued, which struck down discriminatory retirement and promotion conditions for air hostesses. Or you have judgments which directly relate to fundamental rights, which is the Joseph Shine judgment, which decriminalized adultery. But what it really did, it said that, look, Section 497 violated Article 14 and reduced women to property in the eyes of law. It gave women autonomy. And so you do have time and again, be it Shaira Banu's judgment, which held triple talaq was unconstitutional. You have the great Vishaka case, which stepped in and brought guidelines where there was no legislation. There were binding, enforceable guidelines against sexual harassment at workplace. Then you have cases on marital rape, etc. It goes on and on and on. You have the judgment authored by Justice Hima Kohli even on the POSH Act and its implementation, and so on and so forth. I mean, the list is endless
as far as judicial decisions are concerned. So now where is the gap? So on the one hand, we are cognizant that we have so many laws relating to women. On the other hand, there are judicial decisions that are binding, that are enforceable. Then where is the gap? Where is the rub? Where is the disconnect? And there I have some reflections on this. And one really, of course, everybody uniformly says enforcement. Enforcement is lacking, and therefore women are unable to get their rights. Now, I think enforcement is just one of the roadblocks. And one of the major roadblocks I find is financial incapacity and double burdens that women face. Now, for instance, most Indian women simply do not have the resources to navigate a complex legal system. And according to National Commission for Women and Ministry of Statistics and Program Implementation, only about 27.4% of women participate in the workforce compared to 79.6% men. And this reflects economic exclusion. Women disproportionately bear unpaid care work. And MOC, by the same report, indicates women spend nearly 5 hours daily on unpaid domestic work versus 1.4 hours by men. So you limit women, and as Rekha Palli ma'am said it, women, and statistics are there to show that women earn on an average 28% less than men for the same work. So even when you're employed, you not only you face double burdens. So you have very few women in the workforce, you have very few women who get paid well, and then you're asking them beyond this, and plus they also have double burdens at home. And then where is the time, the energy, the money to pursue their rights? And we know, I've been in the system for 30 years now, and legal recourse takes years. So for women to choose between a court date and a day's wage, I don't think that decision, I think it's a very, very clear answer. And it's really a long, winding road to justice, and clearly long, clearly lonely. And I feel that, especially when it comes to, cases relating to violence against women, you face the violence, then you're re-victimized because you go through the process. And at the end of the day, what is it that they have to show? Now look at the NCRB data. Of course, it's a bit dated, it's 2022. Now conviction rates are abysmally low. So you have 27.2% conviction rate in rape cases, you have 35.3% conviction rate in dowry death cases, PCPNDT, which is like prenatal diagnostic techniques where you have sex selective abortions or sex determination, you have barely 6% conviction rate. So what happens? So at the end of all this, it then discourages people from reporting, and it emboldens perpetrators. Victims lose faith, communities stay silent. So I know it's sounding depressing, but that's what I have seen, and I know this is about our experiences. And as a lawyer who's been a practicing lawyer, this is what I've got to see. But yes, but that we can't end any discussion with that. You have to have a roadmap, you have to have a blueprint for the future, and I think the most important starting point would be awareness, and legal awareness in vernacular languages. And I don't know how many people know that the Legal Services Authorities Act provides free legal aid to women. Now, these things is something that people should know, and even apart from legal awareness, apart from better representation for women in the judiciary, and I feel now at least senior advocates, I think there are a lot of us. I'm really, really happy and proud that that number is increasing. Kudos to all of you. I think that is really a tremendously proud moment for me. Most of my juniors have become advocates on record. So, go girls, great. and then apart from the fact of awareness, better representation, and better enforcement, certainly, we also even things like even why do acts don't work? You have an act, you have judgments, why doesn't it work? Now, if we were looking at Domestic Violence Act, for instance, you are supposed the first mile, the first point person for a woman is a protection officer. And we have only about 710 dedicated protection officers for the whole country. And as opposed to 2,655 of them holding just additional posts, doing other things. And so this is where, the gaps are. And but one thing that I know is that our fight should be very sustained. It can't be a knee-jerk reaction. You have Nirbhaya, suddenly you have a spate of amendments. You have something, it shouldn't be a reactionary thing. I think we should not, till our goal is achieved, till we have a better day for women, I think we should push back and in a dedicated fashion continue our struggles. Thank you so much.
Thank you. First of all, thank you to all the panelists for sharing meaningful and deep insights based on their vast journeys in the legal profession. My first question is to Justice Rekha Palli, based on her being on the bench as well as in the bar. Ma'am, my question to you is, how can we as legal professionals help create a more synergy-based environment to make sure that the rights which women don't get access to, or when clients come to us, what can we do better as legal professionals?
The first thing is, as I said, when they come to you, you have to assure them. You have to assure them that they will get their, they should not lose it, because it's a long battle at times. It's a long battle. So your first thing has to be assuring them, making them aware that there are laws for them, and the system is there to help them. As I said, the judiciary and the system is there to help them. That if a lady is reassured and she's made aware, that'll go a long way. That's what I feel, and that's the feeling as a judge also I felt when we were especially dealing with matters relating to violence against women or matrimonial matters, that if you conveyed that feeling that yes, we are going to hear you, we're not going to disbelieve you, the message goes and the effect is much more.
Thank you so much, ma'am. My next question is to Pinky ma'am. Pinky ma'am, because you've had such a long stint representing the government, I think you'll be the best person of the panelists to answer this for us. But what can the legislature or the executive do better? When we say that they need to pull up their socks, we say that the laws are in place, but there is no implementation. What do you think are maybe few simple steps that they can do?
I think auditing. I think we need an audit system within ourselves, whether it's in the judiciary, whether it's in the legislature, whether it's in the executive. Ultimately audit to see what we have done and how we have done. And in fact, you'll find that courts have been engaging their exercise in various PILs. I don't know how many matters where each of the schemes, whether for the benefit of women or for the other vulnerable sections of the society, came up before the courts, and the courts are constantly monitoring. But really speaking, the courts also have limitations. It's ultimately the executive who's handling it and who might be in a better position to call for an audit and possibly accountability. So what we've done, for example, under the food security, we made people answerable for what they do. I think you need answerability in putting the steps that if you don't implement, what happens is we laws saying decide this in X number of months, X number of years, 1 year, 2 years, 3 years, 4 years, they're really fall. It doesn't happen, and Rekha's right, you have to keep constantly giving assurance to people to say, we will get you justice. So access and support, emotional and physical, as well as an audit system within the executive and in fact I would say in the courts, so I think they're doing a lot. But we still need an audit to see why haven't we been able to do various things. And this audit is across board for all issues of human rights, vulnerable sections, etc.
Thank you, ma'am. Now my next question is to Meenakshi ma'am. Meenakshi ma'am, first of all, to hear about fearlessness in women in the 1920s is something I think which will leave all of us inspired today, for each and every one of us here in this room. So thank you for that story. I'll pass this mic to you, not to worry. Yeah. My question to you is there any one pillar which you believe needs more urgent reform or attention in the context of gender justice than the others?
Yeah, one, the gender justice reform, I have two pillars that need a reform and urgent ones. The violence against women keeps women back from attaining their ultimate. So unless and until you don't instill that sense of security in them, you will not get their full potential. The other part is the biases and stereotypes. I believe our biases and stereotypes run very, very deep. We're not going to be able to remove them in one generation. If I say today I go about and talking about it, it's going to go, no, it's not going to happen. But you have an opportunity for the future as you go forward. And I believe in your education system, you must have some curriculum there, catch the children young to recognize equality between genders, recognizing women as your equal partners. When they study that in school and it's imbibed in them, carry it back home, maybe carry it to their parents and maybe larger. You can deal with the adults as you go along, but if you start with the children, you will bring up a generation of young men who will respect women, you will remove the biases, you will remove the stereotypes.
That was very thought-provoking. Thank you, ma'am. Anitha, ma'am, the next question is for you. What's the one reform? It could be legal, it could be systemic, either way. In any of the pillars, which you think would make the biggest difference for women in the next 5 years?
While researching for this speech, I came across something very interesting, and sadly I didn't know about that it was in existence from 2005. It's called gender responsive budgeting. Now, I did not know that all Government of India ministries have a component called gender responsive budgeting. So each ministry, almost I think 40, and Pinky ma'am can correct me, about 49 out of 50 ministries have a gender responsive budgeting. They have a budget to implement schemes for women across all spectrums, be it health, be it education, and now I'm told that even road transport and other ministries have jumped in to have a budget specifically for this. Of course, there are a lot of gaps, which requires, I think, constant monitoring, but having something dedicated to women in these ministries, which I think if they implement it, and it's like a last mile to the last woman, because if it's ministries, then it's across states. It's across all states, all central ministries have this. And if they implement something like this, then I feel all schemes relating to women across all, be it education, health, even access to justice, in any of those ministries, if they have something like this, which can help create awareness, which can help provide financial help, maternity benefits, everything specifically oriented towards catering to a woman, I think if they implement it, I think it will be a very big thing in the next 5 years if they manage to do it.
Thank you, all of you.
Actually, just as a response, Anitha, and Anitha, I've had the pleasure of working a lot together. Thank you very much. But I'm just saying, this gender responsive budget actually works very well. And it does go across. The thing is, you have private sector and you have unorganized sector, which are left out of this array. And that is the problem.
Thank you. Just as a young professional at the bar, this question is for me, which I wanted to ask all of you, because I don't know when we're going to get this opportunity again. In terms of landmark judgments, are there any which stand out to you, so far as gender justice is concerned, either positively or negatively? Shall we start with Rekha?
I would talk about Babita Punia because I will say when I did that matter in 2003, I remember the first lady officer who used to brief me. I used to be an army counsel for some time. She used to brief me and she used to tell, ma'am, I'm going to be out of the system in a few years. I said, why? You are so competent. You're much better than your earlier male counterpart who was briefed. So she said, no, we have only a short service commission for women. And that's when the fight started. 2003, but I'll tell you, the Babita Punia, very few people know. She was not an army officer. She was a junior in my office. The lady officer whose name I can maybe now say was Colonel Leena Gurav. She was so hesitant to come forward to court. She said, the moment I file a case, they will court-martial me or transfer me to somewhere, Manipur or somewhere. So we had to file a public interest litigation in the name of a lawyer. The Babita Punia happens to be a lawyer and now she's a judicial officer in Delhi. That judgment, and then I would, with some sadness or maybe when that matter went before a few benches, the courts were not willing. Some of the benches said, what are you talking, army? With permanency in army, how are we going to interfere in policy matters? And that's the day when it went before a bench which said, yes, it can't be done. Because my viewpoint and my pleading to the court was that if women are good for 15 years or 10 years, what happens to them after? You can't throw them out at 35. You want to restrict the number of women in army, it's a different thing. We understand. So I think I'm partial to that judgment because I remember the army officers telling me this can never happen. And it happened, and that makes me feel very proud that I had that mixture and that lady.
It's not just you, we're all very partial to the judgment as well.
No, 2010, I mean, when it came, it was like we didn't know how to react. It was so overwhelming. So maybe that, I think I'll give the chance to others to talk about that. Though there are quite a few other judgments.
Thank you, ma'am. Thank you, ma'am.
Two judgments. I think Geeta Hariharan, according to me, was one of the most stunning judgments because it gave women rights on custody of children and held them to be natural guardians. The second, which I think recently has become another issue which is very much in vogue, is the question of reproductive autonomy and the autonomy of a woman and the right to a woman's own body and the decision-making process. So starting from Devika Viswas, it's a case that I had done out of Chhattisgarh in Supreme Court, of course, and followed by Suchita, and now, of course, various issues are coming up along that line. And I think constantly we are diversifying, because I do believe that the more important goals are ones which we need to be expanding. We need to be expanding decision-making, political engagement, mental health, issues beyond violence. Violence has been addressed very well in the course of time. But I think the rights which inure to you and give you the capacity to work your full, those are the ones that need to be emphasized, maybe landmark more at this point of time.
Meenakshi.
Okay. So as I said, all of you associate me with Vishaka. But apart from Vishaka, I did the Sakshi, which was on the aspect of at that time when the rape law amendment had not come and there was this young child who had been sexually abused, and we were saying that a digital rape should be treated as a normal rape under 376, and the court said, sorry, our interpretation can't go so far. That led to your amendment in 2013 finally, which became sexual assault instead of just having the rape thing. But with Vishaka and Sakshi apart, the one matter that I thoroughly enjoyed was Joseph Shine. So what had Macaulay said and how had it been interpreted? So there was a case after the adultery provision came in. So an Indian man said, this man has stolen the affection of my wife and I have lost her services. I have lost the benefit of her comfort and her service. So I have to be compensated. Now that is how women were understood to be treated under the Macaulay's law under adultery. And when we took the court to that historical background as to how adultery had come and where only a man was the accused, not the woman. So who has stolen the affections of this other man's wife and deprived him of services? And that's how Joseph Shine came about. You know, they said women are not chattels. They cannot be chattels to their men. But it had a lot of fun because there was a lot of humor also that I found, that how that law had been addressed about 150 years back and where we were today. And it definitely couldn't have stood the statute book anymore.
Thank you, ma'am. Thank you.
Being the youngest, I have so many judgments and I can, in fact, all the panelists, I can name one judgment each. You know, they've all been a part of. I think Pinky ma'am, I don't know if she's forgotten or may not, but she argued, for the PCPNDT Act. It's a case of Foxy and how documentation goes a long way in preventing sex-selective abortions and, documentation by doctors. And Rekha Palli ma'am, of course, the Babita Punia case, and I've known Meenakshi for a very long time, but, for us, when we say Meenakshi and women-related anything, we say Visha. But courts did step in. When they show us out every single day and say, this is policy domain, but no, this was a case where they made a difference. They said, yes, maybe it was not part of our domain, but it was a need of the hour that we step in with guidelines to fill up the gap till the legislation comes along. So, and of course, for me, I feel now language is very important, and stereotypical language that is used, and which affects fairness, which affects dignity, and apart from the handbook of the Supreme Court, which says what is gender neutral language and what is objectionable language, and it's a very much needed. And there is this Aparna Bhatt's judgment, Aparna Bhatt versus State of Madhya Pradesh, where somebody was asked to tie a rakhi. The woman was asked to tie a rakhi on the perpetrator as a condition for bail. And there, in that judgment, there's an exposition of how language matters, how gender-neutral language matters, to empower women. And I have lots of this, but yeah.
Thank you so much to all the panelists. Once again, we loved hearing from you. But I think we now need to conclude this panel. That's all the time we have. But I must thank our audience also. Thank you for being a part of this conversation. And we really hope this conversation has left you inspired and willing to do and willing to act. Thank you. May I now invite Mahalakshmi ma'am to come and felicitate the panel.
I now invite Mahalakshmi ma'am to come and address the gathering.
Good evening and a warm welcome to the esteemed gathering who have joined me to celebrate a momentous day of my life to make it more special. For decades together, the social, economic and political status of women in our Indian society has been an abiding concern to me. Whilst the Supreme Court of India has championed the cause of justice for women across the nation, the host of judgments pronounced by the Honorable Apex Court serves as a testament that not only expands the constitutional mores but also forwards a healthy inclusivity in elevating and pronouncing the rights of women. However, in my practice at the Honorable Supreme Court of India, I say this with conviction that journey of transformative jurisprudence is truly remarkable and deep-rooted in Indian ethos and realities post the colonial era. However, I'm equally concerned about the multitudinous crimes faced by women since infancy. Social behavior, when extracted from biological or gender factors, allows greater freedom to women and girls to liberate themselves from generationally stereotypical roles and expectations. And it is perhaps this pressing concern which compelled me to embark on my maiden literary journey from the womb to the tomb. I hope it acts as a compass, a guide, and a companion for many women who wish to be acquainted about laws enacted for protection of rights. I fervently believe that knowledge is power and is perhaps a potent catalyst for social change. As I was writing this book, a prominent vein of thought that further strengthened my need to write were the multifarious challenges faced by women both in my social environment and also those who have crossed my threshold seeking justice, solace, validation, often because they were unaware of the laws that protect them. It is for them and for every woman who dares to dream of a brighter tomorrow. This book isn't just about laws, it's about empowerment and empathy. It's a rudder for the common layperson, navigating the web of legal complexities. From the sacred bond of marriage to the harrowing shadows of domestic violence, from the widespread secrets of surrogacy and abortion to the battle cries of female feticide. I have delved into the heart of legal provisions that safeguard women's dignity and agency. I extend my heartfelt gratitude to everyone who have assembled here and mark their presence here today as I fulfill a small dream of mine and dedicate this book to my beloved mother and to every oppressed woman who has suffered indignity for generations. Empowered women, empower women. Thank you.
Thank you, ma'am, for such a rousing speech. I'm sure everyone here really felt the sentiments with which the book is being launched today. Carrying forward with the events for today, we are humbled and privileged to have amongst us our chief guest, Justice B.V. Nagarathna, Honorable Judge, Supreme Court of India. Can you please have a round of applause for her? Justice B.V. Nagarathna was born in Bangalore, Karnataka, and did her primary and secondary schooling there before moving to Delhi in 1984 to pursue Bachelor of Arts Honours in History at the coveted Jesus and Mary College. Justice Nagarathna is a second-generation lawyer and judge, being the daughter of Honorable Justice E.S. Venkatramaya, former Chief Justice of India. She completed her law from Campus Law Center, Faculty of Law, Delhi University. In 1994, she began her independent law practice, and within 14 years, she was elevated as a judge of the Hon'ble High Court of Karnataka in 2008. Before joining the bench, she acted as amicus curiae in many landmark and constitutionally germane cases. As a judge of the Honorable Karnataka High Court, she has held the post of the Honorable President of the Karnataka Judicial Academy and President of the Bangalore Mediation Centre. Justice Nagarathna was elevated to the Hon'ble Supreme Court of India on the 31st of August 2021. Since her arrival at the Supreme Court, she has rendered path-breaking judgments on free speech, gender non-discrimination and equality, financial laws, electoral laws, center and state relations. Her judicial opinions reflect her deep abiding commitment to core constitutional values and an aching concern for the last underprivileged person standing on the sidelines of society. She is fearless in the expression of her judicial opinions and has many a time taken the leap against popular judicial opinion of her respected peers. Justice Nagarathna embodies the iconic preambular spirit of public justice and equality. Her scholarly inclinations are extremely awe-inspiring as Justice Nagarathna every weekend travels to law colleges, judicial training academies and seminars, and it is very evident that her commitment to legal and scholastic awareness is an inspiration to all of us today. Thank you, Lordship, for your august presence today. Our guest of honor today is Honorable Justice K.V. Vishwanathan, Honorable Judge, Supreme Court of India. Can we please have a round of applause for Justice K.V. Vishwanathan? Justice K.V. Vishwanathan was born in Coimbatore, Tamil Nadu, and completed his scholastic education from Arogya Mata Matriculation Higher Secondary School, Pollachi, Sainik School, Amravati Nagar, and St. Joseph's Higher Secondary School, Ooty. He later graduated in Bachelor's of Laws, obtaining a first rank from the Coimbatore Law College, Bharatiya University. While pursuing his law degree, Justice Vishwanathan simultaneously interned for 5 years with Mr. K.A. Ramachandran. He moved to Delhi in 1988 and joined the chambers of Senior Advocate Mr. C.S. Vaidyanathan for a period of 2 years before joining the chambers of Senior Advocate Mr. K.K. Venugopal. Justice Vishwanathan started counsel practice at the Honorable Supreme Court of India in the year 1995 and was designated as a Senior Advocate in 2009. He served as the Additional Solicitor General of India from the year 2013 up until 2014. As a Senior Advocate, his contribution to the law has been relentless and has acted as counsel and amicus curiae in many pivotal commercial, corporate and intellectual property matters, apart from conducting intricate constitutional issues touching meaningfully on the canvas of human rights. Justice Vishwanathan has been a member of the National Legal Services Authority and a member of the Supreme Court Legal Aid Society. Justice Vishwanathan was elevated to the Honorable Supreme Court of India on the 19th of May 2023. Justice Vishwanathan is a prolific writer and embodies the spirit of a curious academic. He has penned 36 articles and more, along with columns and a robust repertoire of research literature. He regularly delivers lectures in various law schools across India. Justice Vishwanathan is also an avid sports person with a keen liking for cricket. I thank Justice Vishwanathan for gracing the occasion today. Can you please have a round of applause? Our special guest for today is Honorable Justice Hima Kohli, former Judge, Supreme Court of India. Welcome, ma'am. Justice Hima Kohli had enrolled as an advocate in the year 1984 and practiced in the High Court of Delhi till her elevation as a judge in the same court in 2006. During her practice as a standing counsel and legal advisor to the New Delhi Municipal Council and as an additional standing counsel, Government of Delhi, she appeared in a number of important matters and argued issues of public importance. Her primary areas of practice were in the fields of constitutional law, commercial disputes, and general civil cases. As a judge of the High Court of Delhi, she was appointed and nominated as a member of the National Law Schools at Delhi and Kolkata. Whilst our judges are assuming the dais, I request everyone in the audience to please keep the applause rolling. Justice Kohli is a member of the International Law Association, International Association of Women Judges, and the Indian Law Institute. She is the only sitting judge of the Supreme Court who has been certified by the Singapore International Mediation Center. She is also the founder patron of Women in Law and Litigation, a society of women judges and lawyers based in Delhi. During her tenure in the judiciary, spreading over a period of 18 years, she has addressed several national and international conferences, conclaves, and symposiums on arbitration, mediation, environmental jurisprudence, and women-centric legislations. I wholeheartedly thank all the dignitaries on the dais today, as we are humbled and privileged to have your gracious presence amongst us today. I now invite Honorable Justice Rekha Palli to kindly address the gathering. Oh, sorry. I'm so sorry. Apologies, everybody. I now invite... Okay. I now invite Mr. Nikhil Majidhya to kindly felicitate our dignitaries on the dais. Mr. Nikhil Majidhya, if you could please felicitate Honorable Justice Nagarathna today. I now request Mr. Mahalakshmi Pavani to felicitate Honorable Justice Vishwanathan. Can you please keep the applause rolling? I now request Ragini to kindly felicitate Honorable Justice Hima Kohli ma'am today. I now request our special guest, Honorable Justice Hima Kohli, to kindly address the gathering. Ma'am, I must apologize for the confusion.
As long as the confusion isn't confounded, it's fine. Such a pleasure to see all of you. A very warm good evening on a very hot summer day. Let me start by acknowledging my brother and sister on the dais. Brother Vishwanathan, sister Nagarathna, of course the author of the book, Mahalakshmi, my senior colleagues in the audience, my colleagues in the audience, a scintillating discussion with the panelists. Each one of them have already contributed beautifully to the subject of today. Members of the legal fraternity, distinguished guests, the publishers, the media partners, and the friends from the media. It is indeed a privilege to be present on this evening on the occasion of the formal unveiling of the significant publication authored by Mahalakshmi Pavani, Women Laws from the Womb to the Tomb, Rights and Remedies. To begin with, allow me to rely upon the significance of the legal literature as a tool to bridge the divide between the court and the citizens. I want to refer and reflect on it because the law, for all its sophistication and structure,
remains unfathomable for a vast majority of our population, particularly women, something that was highlighted by members on the panel just a little while ago. This is not due to the absence of rights, but due to sheer lack of awareness. It is this deep void that the book finds its calling. It does not merely recite legal provisions. It contextualizes them, humanizes them, and most important, demystifies them. It is not often that one comes across a work of legal literature that seeks not only to inform the readers, but also to empower them. The author, Ms. Mahalakshmi Pavani, senior advocate, a long-standing legal practitioner with unwavering commitment, holds distinction of being the first woman from Karnataka to be designated as a senior advocate by the Supreme Court. She incidentally was the 6th woman to be bestowed this honor by the Supreme Court of India. This milestone, earned through years of diligent advocacy, relentless pursuit of justice, and unfailing professional integrity, is not just a personal triumph. It's a milestone for all women in the legal practice. This book is in many ways a culmination of that journey that Mahalakshmi has undertaken. A journey marked by service to law, to the cause of women's empowerment, and to the larger idea of access to justice. This work is not merely a book, it's a statement of purpose. It is the voice of someone who has seen firsthand how the law can uplift and how often it fails to reach the very people that it was designed to protect. Having had the opportunity to scan through the book, I must say that it is an exhaustive yet accessible legal companion, one that speaks not only to the lawyer, but also to the student, to the policymaker, to the activist, and most importantly, to the layperson. It is a thoughtful blend of doctrinal clarity and emphatic narrative. The book, spanning over 25 comprehensive chapters, traverses a wide and carefully curated spectrum of issues that confront women in different phases of their life, from personal spaces to professional environment, from family laws to reproductive rights, from violence and discrimination to empowerment through legal awareness. Beginning with the roots of feminism in our country, the author takes the reader on a guided tour through pressing contemporary challenges, from the horrors of female feticide and domestic violence to the complexity of surrogacy, cross-border custodial battles, and intricacies of the POSH Act. Along the way, the reader encounters familiar terrains, as in marriage, maintenance, inheritance, but always seen through the lens that underscores dignity, equality, and justice. Allow me to briefly touch upon some of the themes explored in this book, which particularly stood out for me. One of the early chapters, examining the life and times of feminism in India, sets the tone of the book. It does not blindly import foreign narrative, but examines the indigenous evolution of women's rights within the socio-political and cultural framework of the country. It contextualizes feminism not as a confrontation, but as a constitutional aspiration, grounded in Article 14, nurtured by Article 15, and fueled by the spirit of Article 21. The discussion on sexual harassment in the workplace is particularly relevant. With the Sexual Harassment at Workplace Act completing over a decade and a half since its enactment, there is much ground to cover in understanding its practical application, institutional implementation, and the challenges that are still faced by women in professional spaces. This was something that resonated with me too when I authored that judgment that on the POSH Act. and felt that there was much to be said and done even now after so many years of the Act being on the statute book. Ms. Pavani's treatment of the subject is nuanced. She does not limit her analysis to the letter of the law, but addresses lived experiences, institutional cultures, and the subtle and often invisible ways in which gendered discrimination plays out. The chapter on marital rape, a harsh reality behind closed doors is the title, is written with honesty and courage. It confronts the contradictions within our criminal law framework, where a non-consensual act outside marriage is rape, but within marriage it becomes legally permissible as it stands now. This subject has occupied much judicial, legislative and academic debate, and it's ongoing even now. And yet, meaningful reforms continue to elude us. The author does not attempt to resolve the complex issue in a few pages, but she certainly invites the reader to think, to reflect, and question status quo. Equally compelling is the treatment of surrogacy, female foeticide, and adoption. These chapters go beyond the black letter law to explore ethical dilemmas, social taboos, and the emotional dimensions that women face when navigating these paths. The legal provisions are supported by case law, practical illustrations, and in some instances, anecdotal insights. So it makes a compelling reading. I'm heartened to note that the author has dedicated space to subjects often relegated to margins of the mainstream discourse, as in bride trafficking and female genital mutilation and the status of sex workers. These are issues that affect thousands of women, or shall I say lakhs of them across the country, yet do not find resonance in public conversations. By documenting these concerns, Ms. Pavani has drawn the attention not only to the violence suffered, but to the urgent need for legislative and judicial response. The closing chapters dealing with uniform divorce code, women's property rights, and electoral reforms reflect the author's forward-looking thought process. She does not limit herself to the problems of the present, but dares to imagine a more equitable future, one where equality is not an exception but a default, where protection under the law is not a privilege but an assured guarantee. The book is also commendable in that it includes the annexures of 6 major women-related statutes from MTB Act to the Maternity Benefit Act, which enhances its values as a ready reference for the legal practitioners, legal aid volunteers, and the law students alike. Ms. Pavani is no stranger to the courtroom or to the causes that matter. Her book is a reflection from the prism that demonstrates clarity of law, the conviction of a practitioner, and above all, the compassion of someone who has stood in the trenches of justice. It is clear from the author's note that this book has not been written from a place of academic detachment. It has been written from a place of lived engagement. Ms. Pavani writes as someone who has spent decades fighting legal battles, comforting the vulnerable, and challenging the institutional silences that often surround women's rights. She writes and says that for women who walk the corridor of power or tread the dusty streets, that inclusivity, that instinctive embrace of all women, regardless of their station in life, is what makes the book different. It is not just a lawyer's book, it's a woman's book, it's a citizen's book. Having had the opportunity of going through sections of the book, I must commend the lucidity of expression, the depth of research, and above all, the clarity of purpose that runs through the pages. One does not get the sense that the author is writing only for her peers in the legal fraternity. She has written as a woman speaking to other women, as a woman speaking for other women. as a lawyer who has heard their voices, and above all, as a citizen who believes that a more just society is not just a destination, but a journey that begins with awareness. Law can only be effective when its knowledge is spread far and wide. Awareness is a key word. In the course of my judicial career, I've seen firsthand how legal awareness can become a turning point for a woman's life and her career. I have also seen how lack of it can perpetuate cycles of silence, of suffering and injustice. Books such as these become important instruments in bridging that gap. As the book is being released today, I'm reminded of what Justice Ruth Bader Ginsburg had once said: women belong in all places where decisions are being made. I do believe that this book is a quiet nudge to ensure that women find space in all conversations where rights are being claimed, where laws are being discussed, and where justice is being pursued. I offer my sincere congratulations to Mahalakshmi. Your book is both a scholarly contribution and a deep personal offering. It bears your mark of discipline, compassion, and quiet resilience. May this work find its way into many hands. May it inspire many minds, and it may embolden many hearts. I extend my compliments to the publishers, the editors, and the contributors who have brought the vision to life, and to the readers, be they lawyers, students, activists, judges, or simply, the most important, citizens. I have to say that you must read this book not only to understand the nuances of law, but to understand how the law must serve in transforming the society. Thank you for your attention.
Thank you, Lordship, for such an illuminating speech, which has not only captured the sense of the book, but has also highlighted the importance of legal awareness amongst us today. I now invite our guest of honor, Honorable Justice K.V. Vishwanathan sir, to kindly address this gathering.
Subeda asked me whether the pedestal should be there. Justice must not only be done, but manifestly be seen to be done. My esteemed sisters, Honorable Justice Nagarathna, Honorable Justice Hima Kohli, Judge retired now, my elder brothers, Honorable Justice A.R. Dave and Justice Ashok Bhushan, both retired judges of the Supreme Court, Justice Nidhi Gupta, Judge of the Punjab and Haryana High Court, distinguished members of the audience, ladies and gentlemen, a very good evening to you. At the outset, let me congratulate Mahalakshmi for this remarkable venture of having published the book Women Laws from the Womb to the Tomb, Rights and Remedies. As I speak on the book, I think all of you women lawyers here, judges here, should spare a thought to three women of our country of the last century. Regina Guha, Sudhanshu Bala Hasra, both of whom lost their fight to be enrolled, and Cornelia Sorabji, who succeeded. I was reading an article, and still available on the website of the UK Supreme Court, by Lady Hale, the former president, on women in the law. She traces the struggle that women have undertaken for the past 100 years, and she narrates cogently how initially they were denied enrollment in colleges. And then I think the men relented and said, you can enroll, but we'll not give you the graduation degree. It's all documented. Thereafter, they were told that you could get the degree but can't enroll for any profession. And then they said, even if you enroll for the profession, you will be denied suffrage, the right to vote. So all this had to be fought. So sitting on the panel discussion, so before I really begin the talk on the book, I wanted to make a couple of comments. I was wondering what could be the real causes that, led women to undergo all this ordeal, agony. It could be the denial of education for a large number of years, resulting in economic dependence, which in turn, I think, resulted in a certain stereotype having set in, which was expected, to continue for long. And then because of the numerical minority, they were also perhaps in a position not able to assert their right. So I think all those who championed, in spite of the difficulties which the women were put to, both men and women who championed for their causes, I think deserve an applause, and we should spare a thought for them and congratulate them. Only one comment on the story which Meenakshi narrated. I think it was really an eye-opener. Hailing from Tamil Nadu, Coimbatore, not far away from Madurai. I was not aware of the story. But Meenakshi, I don't think the women lost the fight. I tell you why. They may have lost the fight in the sense that the manager was not removed. But I don't think after the protest, the manager would have ever ventured to commit any of those misdeeds. So in that sense, they actually succeeded in the protest. That was what was crossing my mind. The book is a fascinating book. I don't know how nervous Mahalakshmi is in preparing a case in my court, but preparing to speak at her book release. I had to go through the book, go through parts of it, and go through the wonderful foreword of Chief Justice Rekha Palli. Having known Mahalakshmi, because I was in Mayur Vihar, and one of our go-to seniors was father-in-law, Mr. P.P. Rao. So invariably, being a resident, he being a resident of Noida and me being the adjacent Mayur Vihar, I would get on request the last conference. So, and with Mr. P.P. Rao, we would hear the 9 o'clock news on the All India radio with the 6 beeps. So, having seen her as a young lawyer fighting to, come up, having seen her being designated, I think it's a lovely feeling to stand here to speak at the launch of her book. Chief Justice, the most revered Chief Justice we have had, Chief Justice M.N. Venkatacharya, has written a beautiful foreword for the book. I request all of you to read the foreword before you read the book. And he calls it that the book is truly passion poured on paper. And then he goes on to say, Alluding to Pavani's words that she has stood witness to many a women's unyielding battle against injustice and that she dreams of a country where every woman walks with her head held high, Justice Venkatacharya writes, true to this profound conviction, the 24 chapters of the book analyze every aspect of the problem. The biological difference of sexes is always a matter of celebration. However, historically, women are seen as a weaker sex, subjecting them to scandalous immunities and disabilities. Happily, things have changed and are changing. What were once considered male bastions are now successfully invaded by women, conferring immense benefit on humanity as a whole. It is undeniable that the stunning achievements of science, technology, arts, and culture world over would have been impossible without the creative contribution of women. You don't have to go very far. Of the three of us here, I am the only male who has had the unique distinction of appearing before both of them as a lawyer and being a judge alongside them in the Supreme Court. So that is come a full circle. Rekha Palli mentioned it in the discussion and I thought it was a very valid point. I made a note of it. What makes the book remarkable is the reader's remedy section at the end of every chapter. It's like a ready reckoner. Mahalakshmi dedicates the book to her revered mother and mother-in-law also. There's a nice photograph of the two of them and she mentions that it is to them and to millions of women of our country who are not aware of their rights and remedies. In her humble words, it's a small endeavor on her part to empower women. So the section on reader's remedy is a ready reckoner which will give you the immediate steps that are to be taken. The registration of a zero FIR, the lodging of a complaint, as to how do you enforce and apply the rights that are crystallized in the various statutes. I thought it was a remarkable thing because instead of merely theorizing the subject, if you can suggest methods like this which will help in applying the law, the days when, resort to legal counsel is not very cheap. And our society having women of different economic strata, I think this will be remarkable for them to educate and protect their rights. The author does not stop short of merely walking you down the legal provisions. It's not a mere narration of the provisions. She makes some pertinent observations. Chapter 3, dealing with sexual harassment at the workplace, the author argues that the growing participation of women in the workforce has unfortunately led to a rise in the magnitude of crime against them. Pavani discusses the Industrial Disputes Act, under which a worker can approach the Labour Court for relief if they have been wrongfully dismissed or discharged by their employer for fulfillment of sexual demands or favours. But the point that she makes is, Prevention of Sexual Harassment Act, the POSH Act, introduced the concept of an extended workplace. However, there are limited legal protection for women in the informal sector. She makes a point that the 44 labour legislations in the country are now coded into 4 labour codes. Many workers in the informal sector are left outside their purview due to the establishment-oriented definition that applies to 10 or more workers in certain establishments. So that is how to become an establishment, to become a factory, 20 or more with the use of power, 10 or more. So she says that the informal, unregulated sector needs to be also protected. The new labour code, according to the author, fails to address these gaps adequately, and issues like unequal pay, lack of maternity benefits, and increased vulnerability to sexual harassment during the lockdown remain significant challenges for women in the sector. In the chapter on live-in relationship, the author explores how Indian law has gradually evolved to recognize such partnerships, especially in the interest of protecting women and children. We have all read the principle that long cohabitation, there's a deeming fiction which is brought in succession law, in marriage laws, to deem a marriage. She traces the first of the cases, Badri Prasad versus Deputy Director Consolidation, where the Supreme Court gave legal recognition to a 50-year live-in relationship, stating that when a couple lives together for a long time as husband and wife, a strong presumption of marriage arises. She notes that Justice Krishna had emphasized that the law leans in favor of legitimacy and frowns upon bastardy, placing the burden of proof on anyone seeking to deny such a relationship legal status. Always fascinating to read any opinion of Justice Krishna. And I must tell you an anecdote. 2006, at least 26 years after Justice Krishna had retired, I was in Cochin for a wedding. I was also a young lawyer. It was my fascination to see him. We had known him earlier. So I thought 4 o'clock would be a better time to go because I assumed he would sleep in the afternoon. So when I landed at 4, I found a lot of pamphlets in the house. Sleep was far away from his mind. He had called all the children of the locality and released a manifesto for children that morning. So he spent some time with me, and 2006 I caught the late morning flight and come back. There was an email waiting in 2006. Thanks for calling on a judge. Hopelessly barred by time, with faculties failing. So I wrote back saying that certainly the faculties are not failing and we all have a stake in those faculties because he was very sharp then and contributing on public causes. That's only, by the way, to show that on every aspect you will find some of the stalwarts of our court having pronounced, which we still repeatedly use. In the chapter discussing domestic violence, Mahalakshmi discusses the Prevention of Women from Domestic Violence Act, examining the attempt to address and mitigate domestic violence in India. Prior to the enactment of this law, the author notes there were no specific provisions to penalize domestic violence, leaving women without adequate protection in abusive domestic situations. Thereafter, she traces the development of the law. But I must tell you one other point that the panelists made. I think Anitha made that point of how one must take care that the provisions are also not abused. Because a small segment which abuses them could fetch a bad name to the legislation itself. And both, I think, sisters here and we have observed that sometimes, and I think the blame should lie on the lawyers who perhaps the woman is not even aware of what is being written. Things that are written, and we are occasioned to comment, I had also occasion to comment in a judgment. I don't think the woman is even aware when she signs it. Amendments which are outrageous, and I think care should be taken that that is avoided so that the salutary purpose of this legislation, these legislations are not defeated. I will not labor further because I know that you are all waiting to listen to Justice Nagarathna. I remember somebody asked me to ask Justice Nagarathna whether she would go to Cochin to preside over a school annual day or a 50th or a 60th day. She said, I can't go. Why don't you go? I said, they don't want me, they only want you. In the chapter on abortion, the author addresses the debate surrounding the abortion right. She emphasizes the constitutional right to privacy, which is considered an extension of the right to life and personal liberty. And she deals with the recent judgment of Dobbs and compares it with the development that we have achieved in India, which is far greater. In fact, they have had a setback, but we have been progressive on that front. I think on all accounts, this is a fascinating book. It is a book which should adorn the library of every member of the legal fraternity. It should be a book which should be possessed by every woman so that, she's aware of her rights and she enforces them. I wish Mahalakshmi many more books to her pen. I wish the book all success. Thank you very much for coming over this evening. Thank you.
Thank you, Lordship, for such an insightful speech. I'm sure everyone here enjoyed those anecdotes. And now for the speech everyone has been eagerly looking forward to today, I now invite our chief guest, Honorable Justice B.V. Nagarathna, to kindly address this august gathering. Thank you. Please have you here.
Namaskar and a very good evening to everybody. My esteemed brother, Honorable Justice K.V. Vishwanathan, Judge Supreme Court of India. My esteemed sister, Justice Hima Kohli, former Judge Supreme Court of India. I'm very happy to see former judges of the Supreme Court of India and also both sitting and former judges of the High Courts. The central figure of today, Ms. Mahalakshmi Pavani, Senior Advocate. I know her since mid-1990s when she was a young advocate in Bangalore. And she was in Mr. Siva Subramanian's office. She was his junior colleague. And she gave us a lot of hope in one matter in the Mayor Hall. Because we thought we were losing, but she said, no, you're going to win, and we did win. The esteemed panelists, I was not able to attend to the earlier part, but I really relished their intellectual inputs in the latter part. Learned senior advocates and advocates who are present here today, distinguished invitees, members of the press, electronic media, ladies and gentlemen. It is indeed my privilege to be here before all of you today for the release of the book, Women Laws from the Womb to the Tomb, Rights and Remedies, authored by Ms. Mahalakshmi Pavani, Senior Advocate, Supreme Court of India. I extend my warm greetings and congratulations to her and each one of the persons who have been involved in bringing out the book today. I acknowledge that the book is a conspicuous body of work for reasons more than one. Firstly, the book comprehensively covers the perils and ills concomitant with the potential birth of a girl child, and also includes legal commentary on the rights of women until they become senior citizens, until the tomb. Secondly, the meticulously curated structure and constituent articles of the book not only enumerate the positive description of law, but also expound the intent of the legislator, the judicial intent, and contextual societal setting in which these laws operate. Perhaps this is why Justice M.N. Venkatachalaya, former Chief Justice of India, in his foreword has said, and I repeat, Ms. Pavani's words indeed are passion poured on paper, and that the 24 chapters of the book analyze every aspect of the problem that women face. I would like to briefly discuss on certain aspects of the book, particularly with regard to law's relationship with the journey that spans from the very inception of life to its final moments, a journey of a woman from the womb to the tomb. Central to the transformative goal of our Constitution is the transformation of women as key actors in the society and economy. It is therefore that we have Article 15(3) of the Constitution, which is an affirmative measure to be taken for women and children. The spirit of emboldening women's rights radiates in Rajkumari Amrit Kaur's forceful words to the Minorities Subcommittee of the Constituent Assembly, terming women as technically the largest minority in India, as custom, usage, and even law militated against women. I think that is the necessity and essentiality of this perspective, which explains the commitment to ensuring equality that is explicit on a reading of not only Article 15(1) or 15(3), but also Articles 39A, D, E, and 42. Now this journey commences with what is in the womb, whether the womb has a male or a female. The journey of women's legal protection in India begins even before the girl is born and extends throughout her childhood, adolescence, youth, until the end. In recognition of these systemic biases against the girl child, the Parliament has enacted the Preconception and Prenatal Diagnostic Techniques Prohibition of Sex Selection Act 1994 to curb what is, in my view, the most palpable and heinous discriminatory act, namely female feticide. The Supreme Court in Centre for Enquiry into Health and Allied Themes, SEHEL, and Voluntary Health Association of Punjab gave apposite and urgent directions for adequate implementation of the Act. But I am pained to say that a study conducted in 2020 found that nearly 75% of female subjects questioned in North India were not even aware of the Act and its penalties. The existence of laws is inconsequential in my view if its beneficiaries are distanced and alien to the remedy. In that light, I must acknowledge that Ms. Mahalakshmi rightly calls her book not one about laws, but about empowerment for the lay person. Equally vital is the protection of a woman's autonomy and health during pregnancy. Recognizing this balance, Parliament has enacted the Medical Termination of Pregnancy (MTP) Act 1971, addressing the serious issue of unsafe abortions and affirming a woman's right to make decisions about her own body. What was to be done to decrease the high maternal morbidity and mortality associated with illegal abortions? This respect for personal autonomy of the woman was further expounded and resoundingly broadened by the Supreme Court in Suchita Srivastava, wherein the Apex Court urged the state to look beyond social prejudices as it gave primacy to the personal autonomy of a differently abled woman to decide if an abortion was in her best interest. However, in 2018, a report of the Ministry of Health and Family Welfare notes that about 8% of maternal deaths in India are due to unsafe abortions. Another UN Population Fund report highlights that close to 8 women die from causes related to unsafe abortions each day in India. We must introspect why, despite the Parliament's active step and reforms within the MTP Act, the country still faces a deluge of unsafe abortions as opposed to regulated and safe facilities under the Act. As we move ahead from safeguards protecting a girl child at birth and early childhood, the law seeks to safeguard her rights as she enters adolescence, especially against child marriage and exploitation. On that note, I must appreciate Ms. Pavani for dedicating a chapter to bride trafficking, a scar not highlighted enough in today's legal discourse. Although we have come a long way from the Child Marriage Restraint Act 1929 to the Prohibition of the Child Marriage Act of 2006, we must nevertheless take stock of the perilous situation. Despite the confluence of Section 366 of the Indian Penal Code and the 2006 Act, thousands of minor girls are virtually trapped each year for the purpose of forced marriage. An example of this is what happens in North India on Akatij, or what we call Akshaya Tritiya, when it is supposed to be a very auspicious day when thousands of minor girls are married away as a way to get rid of the responsibility of bringing up adolescent girls. In 2017, the Supreme Court in independent thought read down exception 2 to section 375 of the IPC and raised the age of consent to 18 for married girls, thereby declaring that sexual intercourse with a wife below 18 years of age is rape. In Karnataka, they have said this child marriage is a void marriage. Of course, it is void, not from the point of view of seeking maintenance or any other remedy, but otherwise it has been declared a void marriage. But in other parts of India, it is not a void marriage. However, it is a great dent on adolescent girls' lives. It is incumbent on us as members of the legal fraternity to ensure that the functioning of the legal system is true to the intent of our founding parents, founding fathers and founding mothers, and leads all citizens irrespective of gender. The object of any welfare enactment deconstructing patriarchal barriers is not to militate against men with boundaries of exclusion, but I think it is to redraw boundaries of inclusion that foster collaboration and coordination between men and women. I am reminded of the quote from Mary Wollstonecraft, the famous author, who said, and I quote, "I do not wish them, that is women, to have power over men, but over themselves." We are not anti-men, but we are pro-women. In that sense, I must say that the Constitution 128th Amendment Act 2023, or the Nari Shakti Vandan Adhiniyam, is as significant as universal adult suffrage, because in India there was no discrimination when it came to the right to vote between men and women as in other countries had. It is only a measure of ensuring representation of women in parliament and not an affront to men. I hope that the day 33% reservation for women in parliament is implemented, at least during our lifetimes, we would fondly remember the memories and acknowledge the efforts of our founding mothers and countless after them who have contributed to this struggle. Next, viewed from the same ameliorative lens, the Equal Remuneration Act 1976 is the state effectuating its directive of equal pay for equal work for both men and women under Article 39D of the Constitution. But that does not really happen in all places. Imagine men queuing up, women workers queuing up before the employer, the men receiving one standard of wage, rate of wage, and for the same work, the woman receiving very much little, and nobody is there to correct that. We must remember the succinct distillation and application of the principle by the Supreme Court in McKinnon, McKenzie and Company versus Audrey DeCosta, which was a case where the stenographer, woman stenographer, was paid less as compared to the male stenographer, and for the same amount of work that was done. Similarly, the famous decision in C.B. Muttamma versus Union of India is highly instructive to understand entrenched patriarchy and remedies available to women. In our celebration of C.B. Muttamma, who was from Karnataka, the first foreign service officer, we would be remiss if we forget the structural barriers put up against her in the corridors of power. In that case, the court was called on to decide if a condition in the Indian Foreign Service that forced a woman officer to resign upon marriage or denied them promotion was constitutional or not. The great Justice Krishna, who has been remembered today, rendered the judgment despite the rule being withdrawn, saying that such disabilities based on marriage is a facet of stark bias against women, and observed that, quote, if the family and domestic commitments of a woman member of the service is likely to come in the way of efficient discharge of duties, a similar situation may well arise in the case of a male member. Look how advanced he was in those days also. On the subject of remedies, which is also a great portion of the book, I find most potent Justice Iyer's ultimate observation in the judgment when he says, quote, what we do wish to impress upon government is the need to overhaul all service rules to remove the stain of sex discrimination without waiting for ad hoc inspiration from writ petitions or gender charity. In the panel discussion, it was mentioned how difficult access to justice is. For understanding of the problems of women, ventilating it before the court, right from the court at the lowest level, it may travel up to the Supreme Court, ultimately to seek justice. But The mere existence of the stain of sex discrimination itself must be the impetus for the state. Now we are having a new law commission chairperson who has recently taken over, Justice Maheshwari, former judge of the Supreme Court of India. I would appeal to him to review all these laws where there is discrimination against women and give successive reports so that the implementation of the laws is not again met with discrimination within the laws. Moving further, a constitutional system aiming for substantive equality necessitates the absence of state-perpetuated discrimination as well as state-led positive steps to accommodate the deserving. I come to the Maternity Benefit Act of 1961 because I am moving from the womb to the tomb. Now the woman is at the stage of maternity benefit. With that legislative intent, the Parliament has enacted the Maternity Benefit Act and its recent amendments. Worth applauding is that Section 5 of the Act provides for up to 26 weeks of maternity leave or 6 months, among the longest in the world, which is really to be appreciated as far as India is concerned. I find that much of the criticism of maternity leave is unfounded and with respect antithetical to constitutional values. Because you see what happens, there are some employers who always ask a woman, sometimes in certain employers, what her last menstrual date was. This is in order to find out as to whether she is pregnant or expecting, because they don't want a new entrant to the job to suddenly ask for maternity leave, because they have to pay the salary, give the leave to her, and somebody else has to work. This is highly not only against the dignity of a woman, but also discriminatory. As an employer benefits from the ecosystem for commerce and stability that the Constitution facilitates, it is equally obligated to render its obligations to a society which benefits from maternal and infant health. Such were the observations recently by the Supreme Court in Shalini Dharmini versus State of Himachal Pradesh, where the court seminally advanced jurisprudence and realized the true spirit of Articles 19(1)(g) as well as 14, 15 and 21 by observing that the absence of a provision for a grant of childcare leave may well push a mother out of the workforce. Many a times when you see young women who get pregnant and ask for maternity leave, they are not yet, made permanent in their jobs. And inevitably when they go on maternity leave, there is somebody else who is substituting them. And ultimately there is a termination of their job. They say, look, somebody else has come, now you have lost your job. Can a woman lose her right to livelihood, her job, her occupation, because she is the only person on this earth who has not only the right, but also the duty to bear a child. And for that, she loses her right to livelihood. Next, the web of laws must ensure an adult woman's right to a safe working environment, which is free from sexual harassment. I need not go in detail to the Vaishaka judgment, but judicial guidelines put in place under Article 142 of the Constitution has facilitated the evolution of a grievance redressal mechanism for victims of sexual harassment. The series of judicial orders have culminated in the POSH Act of 2013. Recently, 2023, the Supreme Court has passed another set of directions, I think by my learned sister, Justice Hima Kohli, which we are following up in certain matters, so that the aggrieved woman can take recourse to legal remedies. One is awareness, the second is access to ventilate the grievance. From the girl child in the womb to a young girl in school, an adult woman at work or in marriage, and finally a woman in her twilight years. Indian law today provides a lattice of protections and rights at every stage of life. But how far are those remedies available to her is the question. Yet, we are stumped with two troubling realizations. Every claim of maternity leave is seen with a hint of freeloading. Claims of equal remuneration are shot down by extraneous factors. On the contrary, how do we ensure that the intent of these remedies is not stultified by misuse and false claims, which we are seeing recently in the courts, particularly with regard to complaints made on Article 498A of the Indian Penal Code. In a day and age of rampant misuse of laws, the impetus has fallen on the judiciary to see through false claims and ensure that the intent of the legislator is not left in the lurch in genuine cases. The judge is obligated to be meticulously aware of the practical realities of society and identify the distinction between a claim weaponizing the law and another praying for justice. To this end, a judge's tools are two: fidelity to the law and a compassionate conscience. Let me remember certain trailblazers. Although Cornelia Sorabji, Mitten Lamb was remembered by my learned brother, I would add Justice Anna Chandy, who was the first woman district judge and the first woman high court judge. In fact, I must remember, my father used to always keep repeating about Justice Anna Chandy to me. I don't know, he said take inspiration from her. And Justice Fatima Bibi, the first woman to be appointed a judge of the Supreme Court of India in 1989. But outside the law, Anandi Gopal Joshi is the first Indian woman to graduate with a degree in medicine in 1886. Then A. Lalita became the first woman engineer in India and went on to design transmission lines for the substation in Bakra Nangal Dam. Mrs. Anna Ranjam Malhotra is the first woman to become an officer of the Indian Administrative Service in 1951. Srimati Sucheta Kripalani, the founding mother of the Constitution, was the first woman Chief Minister of Uttar Pradesh in 1963. Bachendri Pal became the first Indian woman to climb the Mount Everest in 1984. And in 2000, Karnam Malleshwari became the first Indian woman to win the Olympic gold medal for weightlifting. But I must today recall Asha Purna Devi, who in 1976 became the first woman to be awarded the Gnanapita Award for her magnum opus, Pratham Pratishruti, which narrates the life struggle of Satyavati, an 8-year-old girl child given away in marriage and bound in patriarchal shackles throughout her life. Her story is indeed heartrending. Defeated and disillusioned by the artificial limitations imposed on her, Satyavati leaves her familial bond behind and decides to retire to the ghats of Kashi. Upon being questioned by her husband on this extreme step, when Satyavati herself was married as a child, she asked why she was opposed to her daughter being married as a child. She realizes that her independent quest at Kashi is precisely to find answer to this societal injustice. Asha Purna Devi's decision to title her work Pratham Pratishruti is indeed poignant. On that point, I would like to address what is often labeled as a paradox. Unfortunately, a section of society questions why women within the family unit must be financially supported. The answer lies in the fundamental truth that family has been the cradle of our traditions, the sanctuary of our emotions, and the bedrock of our social stability. Thus, both financial security as well as security of residence of Indian women have to be protected and enhanced. That would truly empower such Indian women who are often referred to as homemakers and who are the strength and backbone of an Indian family, which is the fundamental unit of the Indian society, which has to be maintained and strengthened. It is needless to observe that a strong Indian family and society would ultimately lead to a stronger nation. But for that to happen, women in the family have to be respected and empowered. Finally, I would like to say that we think about how women's roles have changed in public life, especially in professions historically dominated by men. It is important to pause and consider the words we use to describe these shifts. One of the learned speakers spoke about language. we frequently hear phrases like women entering the judiciary, claiming a seat in the boardroom, or making their way into fields of power and influence. On deeper examination, however, they subtly suggest that these spaces weren't meant for women, that their presence is unusual or even intrusive. This language echoes outdated beliefs that power, decision-making, and intellect naturally belong to men. There is a loud but subtle declaration that portrays women as outsiders rather than rightful participants. This kind of language isn't just old-fashioned, it is fundamentally inaccurate in my view. Concluding, I would like to highlight that women aren't intruding. They are not taking over or stepping into someone else's territory. They are citizens, contributors, thinkers, and leaders in their own right. What's happening today isn't women invading men's spaces, but rather dismantling barriers that have unfairly excluded them from generations. Every woman stepping into a courtroom, legislature, or boardroom today isn't expanding her boundaries. She is reclaiming her fair share of this nation's intellectual and institutional legacy. As we continue discussions about inclusion, equality, and justice, let's choose our words and language carefully. The fight is for gender equality, not about exclusion, but about removing barriers that kept women out. Women aren't newcomers, they have always been there and here. Concluding, I again congratulate Mrs. Mahalakshmi Pavani on her magnum opus and her setting her sights on empowerment for the lay person. My good wishes to the publishers and everyone who has been involved in bringing out this wonderful book. I think we should all give Ms. Mahalakshmi Pavani a standing ovation. I am the last speaker, but I hope I have not tested your patience. Thank you again. Namaskar.
Thank you, Lordship, for such an insightful speech and also taking us on a unique yet poignant journey from the womb to the tomb. I now request all the dignitaries on the dais to kindly release the book. Can we please have a roaring round of applause? As we near the conclusion of the program today, I now request Mr. Anitha Pavani to kindly deliver the vote of thanks.
My Lord Justice Nagarathna, my Lord Justice